First is a line amendment to line 83. It would add after the words, upon motion of the respondent for good cause shown, the court may continue the hearing. It would add the words, or set a sooner hearing date. Similarly, in line 162, after the words, upon motion of the respondent for good cause shown, the court may continue the hearing, it would add the words, or set a sooner hearing date. The purpose of the amendments is because this bill would allow the court to set on its own discretion a later hearing date. It would allow the respondent, if they don't like that, even though normally they do, but if they don't, they could move and ask for it to be done from there. So that's what the amendments do, and I'll be happy to talk about it.
What amendments are we talking about?
Mr. Chairman, I can read that back. So on line 83 of the bill, after the hearing, at the start of that line, you would insert or set an earlier hearing date. And then it's going to be the same line amendment on line 162. After continue the hearing, it would say or set an earlier hearing date.
Okay. What's the issue you're trying to fix with this bill, first of all, before we get into
Oh, sure. So the purpose of the bill is when someone seeks a protective order. Many times there's also a related criminal case. Many times there's not. If there's not, this bill doesn't affect it. But when there is a related criminal case, what happens 9 times out of 10 is that the person who's seeking the protective order, who got the ex parte protective order, comes in on the 15th day. They're ready to testify. They took off work. They're emotionally prepared to face the person who may have abused them. They come in and the defendant's counsel stands up and says, oh, we're moving it to the criminal date, which is a week later. And then the court invariably,
it's
almost
3
always,
months later, probably.
some it could be 3 months later. But what happens is normally, and the advocates will tell you this happens very frequently, they come in and say, defendant says we want them consolidated together. So for the victim, they've come to court on the 15th day, they've prepared emotionally, they've taken off work for no reason at all when these things are regularly continued. So what the bill does is it says that the court, in its discretion, can set it for the later criminal date, which is usually when the criminal defendant wants it anyway. And if they don't want it, the line amendment says they can still have it earlier, they can ask the court to have it earlier. But this is for judicial efficiency. Most of these cases end up on the later criminal date anyway. This allows the court on their own motion to say, oh, this looks like one of those cases, we're moving it to the later date on our discretion. And again, if the criminal defendant wants it earlier, they can certainly ask for it earlier. That's what the line amendment makes clear.
Sure. What happens now? I thought this was, yeah, I am, right? What happens now?
Mr. Chairman, now the preliminary protective order returns are set for a 15-day hearing. The defendant, the respondent, has the right to continue it for any reason that the court finds good cause. Typically, in my practice, if I've got a criminal client who has a protective order as well, I ask the court to continue the case to the criminal case day.
Okay.
And so that's the practice right now.
Does this change that again?
So under current law, the victim, the person who has the protective order, for no reason, comes to court on the 15th day, takes off work, prepares her testimony, prepares psychologically, and waits in court. The court says, oh, this has been continued to the criminal date. So she or he has wasted her time and taking off work really for no reason, because she doesn't know that it's been continued until she shows up on day 15. And so this would allow the court to say, typically when we have these cases, they move it to the criminal date anyway. They would notify the respondent, we're moving it to the criminal date. She wouldn't have to show up in court. She wouldn't have to take a day off work. Frankly, it really helps with judicial efficiency, and the vast majority of respondents want this.
Yeah. I'm just wondering how this fixes that, and I'm still not clear on that.
Oh, well, the line amendment doesn't fix it, but the text of the bill fixes it.
Okay.
The text of the bill says that it's held 15 days, and if there's no criminal case, that stays the same. So the hearing should be held within 15 days of the issue of the preliminary order, unless this is line, well, we can do it in 2 ways, but we'll do it in line 76. unless a hearing or trial date for a related criminal offense has been set and is later than the 15 days, in which case the hearing for the protective order may be held on the same hearing or trial date as related criminal offense. So to allow the court, in the court's discretion, to say, we're going to push it off till the criminal date, which is our general practice anyway.
Yeah, that's what I keep coming back to. So how does this solve your, somebody took a day off work to come to court problem?
Because the court would say, before the 15 days are up, we've moved the hearing date till July 12th, come back then. And the person doesn't have to take a day off work.
Tell you on, I don't know.
So, I guess a couple of general statements and questions. First, the preliminary protective order hearings continue to protect the Fifth Amendment rights of the defendant, and it's done so at the request of the defendant. But as a prosecutor, I've certainly seen circumstances where the defendant very stupidly came in and testified during the preliminary protective order hearing and incriminated themselves. And I was just sitting there in the back of the courtroom taking notes. And it benefited the Commonwealth in those cases. They have every right to be able to do that if they so want to in this civil matter.
And this would allow them to do that. All they have to do is say a motion, we want to be heard on the 15th day.
I know, but by doing it this way, you're reversing the impetus to put it on the criminal defendant to volunteer that they want to come into court to incriminate themselves. And I guess the other question is how do you give notice to the parties?
Because we have to serve.
Yeah.
Mr. Chairman, so the other small, this is common practice, okay, so this is not a new thing we're doing here, but the problem is that we have to serve the parties with the new protective order. So if the judge says, obviously the preliminary protective order, even if the magistrate issues at the same time they issue a domestic assault and battery charge, so let's say, they set the preliminary hearing date and return on the, not every magistrate does it that way, by the way, which is very annoying. But let's say that they do it right, they put it on the same day, the protective order expires that day. So the judge would have to issue another preliminary protective order for the next date that they set for the hearing on the trial, and then have to serve not only the defendant but also the respondent with that new protective order.
Well, they wouldn't have to do that because the code already says that the preliminary order shall remain in effect until the hearing. So the judge could, at the moment it issues the original notice, say, I understand it's a criminal related matter, we're not doing May 12th, we're doing July 12th. So they could, it's clear that under the code, the order would extend that far.
But, okay, on the protective order itself,
Right.
the magistrate writes on the bottom that this shall expire on that date at midnight, okay? So the court would then have to issue a new expiration date. If everybody did it all at the same time, we set one big trial date 2 months out, we wouldn't have this issue. But of course, we want to make sure that everyone has a hearing date within a very short amount of time, because some victims come in and they go, you know what, it was a terrible, horrible idea that when I got this, I would like to not go forward with this. But we're going to have to serve everybody again. And if someone can tell me I'm wrong, that has been my practice in every circuit that I've ever practiced in.
I certainly would have no problem adding a friendly amendment saying that if the dates change, that there has to be new notice given. I'd have no problem with that. But understand what this would do. In the vast majority of these cases, the practice is the victim sometimes hires an attorney, has to take off work, has to be emotionally prepared, ready to face their accuser, and they go in, and 9 times out of 10, it's all a waste of their time, and they're like, why am I even here? Why is the system? And what this is trying to do is say, because this is what happens the vast majority of the time, and it allows an out for the people that don't want it to happen this way. It lets everyone know up front so that no one's wasting time and judicial efficiency, and if there has to be another notice sent out, I have no problem with that, and we could put that in the code. And I do have some advocates here that want to talk about why it's...
All right, anybody here wishing to testify in favor of the bill, please come forward. And if anybody wants to address any of the concerns that have been raised, please do that also. Thank you.
Good afternoon, Sushila Barkey from Virginia Poverty Law Center. This is common practice as far as I understand, and I do think the issue is what Delegate Collins is mentioning, making sure everyone has notice of this new hearing. But other than that, I support this bill and putting it in the code.
Thank you. Yes, ma'am.
Good afternoon, Mr. Chairman and members of the committee. My name is Patty McComas Hall. I work for Hanover Safe Place, and I have personally been in court with many clients who have experienced the situation. In fact, the vast majority of the clients that we work with end up coming to a final protective order hearing only to have it extended to the criminal hearing. They've had to take time off of work, they've had to spend money to hire an attorney that they often don't have, and it causes additional trauma that they've had to show up to court for a hearing that doesn't happen. And while I agree with Delegate Herring that sometimes there are issues when that does help the prosecution, from a victim standpoint, this just causes additional trauma, and Hanover Safe Place supports this bill.
Mr. Chairman, if I can ask a question, real briefly, I don't want to belabor the point too much. And I recognize I have also been in court with victim. Now, if they hire me, because now it's leading into a divorce, I just show up for my client. I say, you don't have to show up, we're going to continue because of Fifth Amendment rights. But if the victim, if the protective order expires on that day, at that time, and they say, you tell them, you don't have to go because they're just going to continue it to the trial date for the criminal matter, and now it expires, and the respondent is not served, there's maybe a potentially 3-4 day window where the protective order is no longer in play. Because in order for the protective order to be enforceable, the respondent must be served with the protective order that says no contact, don't go to the house, etc., etc. So you're right, this is common practice. But my concern is that we have a protective order in place that now expires, and until the respondent is served with the new protective order, there's a gap. And is that not a concern for you?
It would be a concern if that extension isn't done until the 15 days are up. If that extension is done either at the date of the original preliminary order or within a couple of days of that, then there should be enough time to get that person served.
Mr. Chairman, thank you, ma'am.
May I ask one additional question? I certainly understand your circumstance and the circumstances of your clientele who are going through these horrible and traumatic events. I spent the majority of my professional career trying to protect them. Couldn't the same problem that you were talking about be fixed with victim witness officers who are managing expectations for victims at that point? And telling them, by the way, this is likely to be continued, so.
From a psychological standpoint, yes. If they know, and we do that. Our court advocates often will explain to them that it's most likely going to be continued, but they still have to be prepared in case it's not.
If I could address that briefly, part of the problem is we can't know the victim may show up that day and the defendant's counsel comes in, and even though 9 times out of 10, 9 times out of 100 is continued, what if it's not? What if the defendant's counsel is there, sees the victim not there, and says, you know what, I'm going forward, she's not there. It allows them to play games with the system. This way, the court ahead of time let everyone manage expectations and know when the date's going to be. Otherwise, I think the victim's counsel would be wrong to say, don't you have to show up? Because otherwise, they can play games and seek that continuance at the last minute. The problem is the continuance isn't known until day 15, and that's a problem for the victim.
Couldn't the court continue this on the 14th day and then nobody knows for the whole week?
If you would want to make a friendly amendment to say the court has to do this within 5 days or something, I'd be fine with that. But the goal is to make sure that the victim, I mean, how can a victim witness tell the victim, you probably won't be able to do anything, and yet you can't guarantee it under the current law because on the 15th day, it could go forward.
So the current law requires personal service on the individuals who are parties to the protective order, because we don't want to have something like posted service where we say, oh, we think we got it or not. We incur criminal liability on people because they have had personal notice of it. If they're not in the courtroom, are we just going to keep tracking down the 2 ways to protective order hearing, and if we don't find them, then what do you do?
I understand the question. The defendant would be served.
And so would the victim.
Right, but Oh, of the new date? Well, the new
Right.
date, I'm sorry, I don't understand your question. Under
Okay,
current
since
law,
no one understands, let's just take a break here from the questioning. Let's see if we can get that answered. I would like to hear from everybody else in the audience. Please come forward.
Mr. Chairman, members of the committee, John Figliosis with the Virginia Sexual and Domestic Violence Action Lines. I do not have an answer to that question, but I am eager to figure out how to work out some of those kinks. If there's a way to make sure that the issuance of the PPO is something that's effective and consolidates court dates and it remains intact, that's something that we and our advocates certainly support. And I think Patty spoke to all those reasons why.
Patty Longman-Arthur with OES of the Supreme Court. We have no position on the bill. Just to clarify process, I do the protective order form, so I know what they say. I think what's contemplated by this bill is that at the time the court issues the ex parte PPO, the court, on the back of the form, puts the date of the full hearing. So instead of putting a hearing that's within 15 days of the issuance of the PPO, if the criminal date was 2 months out, they would put that date as the date of the full hearing. What that means is the preliminary protective order is in effect for those full 2 months, but that is the process issue. The respondent would be served with the PPO. It's just a question of whether the date on the back is within 15 days or it's 2 months out. That's the process issue.
Thank you. Yes, sir.
Jim, Mike said, Executive Director of Virginia Association of College Attorneys, and of course it's important to remember that there's a distinction between an EPO, which is issued by the magistrate, and a PPO, which is issued by the court. And I think the OES has made those times very clear. This is a bill that does codify the existing practice in a lot of ways. But it is victim friendly. It does allow, as the patron has pointed out, it does keep from the gamesmanship that they could go on. I understand Delegate Mullen's comments. I have never seen that happen. I'm interested to hear that it happens in Suffolk, but I'm sure it is. But generally what happens is on the criminal matter, they will have their advisory date, they'll come in, they'll get appointed an attorney, and that attorney will say, whoa, you're not even going to go near that courtroom on that 15th day for that PPO, we're going to take care of that at the particular point in time. So this is a victim-friendly bill, and it's a judicial economy bill. It keeps the court from having to docket and 10, 15, 20 minutes, whatever they had to do for that particular final preliminary hearing order, being final protective order hearing, and it's a matter of judicial economy.
Thank you. Counsel.
To make a comment for those people who are getting served on these, what this bill is doing is saying that somebody can come in and it's an ex parte hearing, so the respondent is not there, and a judge can say, I'm going to issue a protective order that keeps you out of your house, takes your cell phone away, makes you pay the bills for somebody else, takes your car away, and I'm going to set it for 3 months from now. And I'm going to say, now the onus is on you, Mr. Maybe unrepresented, maybe not, doesn't know what's going on, to come in and say, no, I wanted to have a hearing before that. When the current law is, we're going to do it in 15 days, and only the respondent has the right to continue a protective order. The petitioner cannot continue by law a protective order. And so that's what the current law is. This is the practice, but just to understand what this bill does is it allows the court, when the respondent's not even there to agree or disagree with it, to set a case that could be out 2-3 months before they come back to court.
Delegate Collins.
Mr. Chairman, I want to make a motion to table this. And the reason is that I think that this is something that we're not going to be able to fix on the fly on Friday afternoon.
Okay. Motion is table. Is there a second? Second. All right. It's non-debatable. Please cast your vote. Okay. Close the roll. And then let's lay it on the table.
Thank you, Chairman.
Delegate Burr.